Donald Trump is at it again. In between threats to arrest his political enemies, rants against the globalist dummies at the Wall Street Journal, and jokes about Ron DeSanctimonious, the four-time indicted ex-president is targeting a new foe, the 14th Amendment to the Constitution. Quote, "It is just another trick being used by the radical left communists, Marxists and fascists to again steal an election that their candidate, the worst, most incompetent and most corrupt president in US history, is incapable of winning," he posted on social media last week without any hint of irony. You've heard of old men yelling at clouds, but old men yelling at the Constitution? For once, it's not just the ramblings of a perpetually paranoid malcontent. There really is an effort underway to remove Donald Trump from the presidential ballot, in fact, from any future political ballot, and it's grounded in the Constitution, specifically the 14th Amendment, the one passed in 1866 after the Civil War to grant citizenship to freed slaves. But it did a whole lot more than that. It also banned Confederates from holding office. Section 3 of that amendment reads, quote, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof." Yes. Finally, opponents of the former president and defenders of democracy have recognized there is a possible constitutional tool at their disposal that disqualifies people who have engaged in insurrection from holding office. Given Donald Trump incited an insurrection in front of all of our eyes on January the 6th, 2021, here goes the argument. He is now disqualified from office. Has anybody ever suggested anything like this before? So if you're concerned about democracy and Donald Trump, yes, there's the DOJ's investigation and the FBI search and the 1-6 committee. But don't forget about Section 3 of the 14th Amendment. A very wise man speaking to you a year and a day ago. But I'm just a lefty non-lawyer. Why would you listen to me? Thing is, you don't have to. You could listen to law professors William Bode and Michael Stokes-Paulson, two conservative scholars affiliated with the right-wing Federalist Society, who published a 126-page paper on Section 3 in the University of Pennsylvania Law Review last month. They say it disqualifies former President Donald Trump and potentially many others because of their participation in the attempted overthrow of the 2020 presidential election. And, crucially, they add, based on their research and investigation, quote, "Section 3 is self-executing, operating as an immediate disqualification from office without the need for additional action by Congress." And they're hardly alone on this. They're joined by Republican former federal judge Michael Luttig, who testified against Trump before the January 6th committee and who just last month told my colleague Ali Velshi this.
The original meaning of Section 3 disqualifies the former president from ever holding the presidency again.
But the thing that has Trump so upset is that it's not just conservative scholars and retired judges saying this stuff. It's that liberals and even some conservatives have actually already got the ball rolling on lawsuits to potentially remove Trump's name from the ballot in multiple states, in Colorado, in Minnesota, in California, even Oklahoma. Many state officials are finding the case pretty persuasive. Here's Colorado's Democratic Secretary of State, Jena Griswold.
Trump is a liar with no respect for the Constitution. To say that a section of the 14th Amendment is election interference and considering how to uphold the Constitution is election interference is un-American. We know that the former president is a liar who will do everything he can to hold on to power.
But another Democratic Secretary of State, Jocelyn Benson of Michigan, told Politico this week that it's ultimately not up to officials like her. Quote, "The bottom line is it's not about us at all. It doesn't matter what a Secretary of State does because we expect the Supreme Court to be the final arbiter." Yes, this will for sure end up at the Supreme Court with its 3 Trump-appointed justices and its conservative supermajority. But so far, in the lower-level courts, the 14th Amendment was successfully used last year to remove a New Mexico Trump supporter from a county commissioner's office after he participated in the Capitol insurrection. And last year, an appeals court left the door open to disqualify GOP Congressman, then Congressman Madison Cawthorn, from office for his role in inciting the insurrection in a lawsuit that became moot when Cawthorn lost his re-election primary. But of course, Neither of those cases come close to the banning of an ex-president. In fact, former George W. Bush Attorney General Michael Mukasey wrote in the Wall Street Journal last week that Section 3 of the 14th Amendment cannot apply to Trump because, he says, it only applies to officers of the United States, which he says means only appointed officials, and the president is, of course, elected, not appointed. The president isn't an officer of the U.S., really? But there is a bigger concern expressed by, of all people, never Trump conservative and ex-George W. Bush speechwriter David Frum. He writes on Twitter, suppose secretaries of state in one or more swing states succeeded in keeping Trump off the ballot. Then suppose President Biden wins re-election by winning the electoral votes of states that debarred Trump. What does this country look like afterward? Chaos. He's not wrong. But then, chaos is Donald Trump's brand. Chaos was what he unleashed on democracy and on the Capitol. You think chaos isn't on the table if Trump is allowed to run again? So, can Section 3 of the 14th Amendment really spell the permanent end of Donald Trump's political career? Is its use an appropriate and viable constitutional remedy, or just magical thinking from the hashtag resistance? Let's ask two experts with two very different views, because it's time for an actual debate. Michael McConnell is representing the Dream On side of this debate. He's a professor at Stanford Law School and a former federal appeals court judge appointed by President George W. Bush. He warned this week that trying to disqualify Trump under the 14th Amendment would begin a cycle of, quote, mischief of people going in and challenging the eligibility of their political opponents to run. On the other side of the debate, Ilya Somin, law professor at George Mason University and also at the Cato Institute. He's no leftist or progressive, and yet he wrote last week that any risk associated with invoking the 14th Amendment is, quote, worth it. Thank you both for joining me today. Professor McConnell, let me start with you. As we mentioned, the UPenn Law Review piece, the one that's really been stirring people up about the 14th Amendment to disqualify Trump, it argues, quote, Section 3 is self-executing, operating as an immediate disqualification from office without the need for additional action by Congress. It can and should be enforced by every official, state or federal, who judges qualifications. Why do you disagree with that?
Well, I don't. I do think the provisions should be enforced by those who are entrusted with judging qualifications. But who are they? You know, just in today's paper, the Secretary of State of New Hampshire noted that the laws of New Hampshire require the Secretary of State to put on the ballot everyone who files the necessary paperwork. There is no discretion. Every state is going to be somewhat different. And then it's going to get up. I think you're quite right that it's going to get up as soon to the Supreme Court as soon as a state decides to kick him off the ballot. The Supreme Court is going to have to look at that.
Professor Somin, your view on the self-executing nature of this section?
I agree that it's self-executing, but it's also the case that once election officials make initial decisions about this, what they do is subject to judicial review in state court and likely in federal court as well. So I agree that if it was just up to some partisan election official, Professor McConnell would be right to worry that they would try to disqualify their opponents and get away with it, but it wouldn't be up to them alone. What they do could be challenged in court, and judges who are not beholden to one political party or another, if the power was being abused to disqualify people who are not legitimately disqualified, then the court could overturn that decision, just as has been the case with other disputes over election qualifications in the past.
Judges who are not beholden to one party or the other. There seem to be fewer and fewer of those around these days. Professor Somin, we've pointed out that Section 3 specifically disqualifies candidates who have engaged in insurrection. It is worth noting that though Trump has some pretty damning indictments on both the state level and the federal level, none of the charges against him are actually for insurrection. So can the system still disqualify him from running even if he hasn't been officially charged with insurrection?
Yes, absolutely. Section 3 of the 14th Amendment is not a criminal law. It's a disqualification for holding certain kinds of public offices, no different from the constitutional requirement that, for example, you have to be 35 to be president, or that other requirements are in the Constitution. So there's no need for a criminal conviction or any kind of criminal proceeding in order for Section 3 of the 14th Amendment to be used, just as with other election qualifications.
Professor McConnell, your response: there's no need for a criminal conviction or indictment. It's just like the age requirement?
Well, what's important here is that the Department of Justice has all the evidence. They know much more about than we do about what the actual evidence shows. They have had every incentive to bring insurrection charges if the evidence supported that. They've prosecuted several hundred people. They've lodged 2 different indictments against Donald Trump. And none of those people have been charged with incitement with insurrection or incitement to insurrection or anything of the sort. There doesn't need to be a criminal conviction, but there does need to be evidence. And the people who are in the very best position to judge whether that evidence is there have evidently come to the conclusion that there isn't. And there's good reason for that, because insurrection is a very strong word. And by the way, the Constitution, Section 3 refers to insurrection against the Constitution. It's not just you don't like the people in office. You're trying to overthrow the entire system. Well, I don't know. I wasn't there. I haven't talked to any of these folks, but I'd be very surprised if the people in the Capitol on January 6th were trying to overthrow the Constitution of the United States. What they thought they were doing wrongly, illegally, reprehensibly, terribly was to correct what they thought was a fraud on the election. I should point out that the Oath Keepers and others have been charged and convicted with seditious conspiracy, among other pretty serious crimes. Not insurrection. Totally different crime. Professor Soman, do you want to respond?
Yes, absolutely. I think a criminal trial and conviction is very different from a civil proceeding, like when you invoke Section 3. Among other things, a criminal conviction requires proof beyond a reasonable doubt, and it has various procedural rules that might make prosecutors reluctant to bring charges which do not apply in a civil proceeding with Section 3. As for whether this insurrection was really against the Constitution or not, I think it very obviously was. One of the bedrock precepts of the Constitution is that the person who gets to be president is the person who wins the election as counted by counting the legitimate electoral votes. And the people on January 6th who attacked the Capitol, and also Donald Trump, who inspired them and who did much to try to overthrow the election result, they were attacking that very fundamental aspect of the Constitution. It was an insurrection against the Constitution and against the United States more generally in a very obvious way.
Professor Soman, let me ask you this. Former Attorney General Michael Mukasey argued in the Washington Post last week that the insurrection clause would not apply to Trump, even if it was an insurrection, because, quote, the use of the term officer of the United States in other constitutional provisions shows that it refers only to appointed officials, not to elected ones. What do you make of that argument, especially given the president takes an oath to faithfully execute the, quote, office of president?
I think it's a really bad argument. The Constitution multiple times refers to the presidency as, quote, an office. Moreover, it would be ridiculous to say that the one office holder who is not subject to disqualification if he engages in insurrection is the highest office holder in the land, the President of the United States. It would just be utterly ridiculous to come out with a reading like that, and only the most overwhelming possible textual evidence could even begin to justify a reading of the Constitution like that. And the people who argue for this reading, there's some smart people, but in this instance, they're just very badly wrong.
Professor McConnell, put aside all the other arguments we're using about the 14th Amendment, Section 3. Do you agree with AG Mukasey that Trump is somehow beyond its reach?
So I have to say, I think the evidence on both sides is very powerful. There's conflict. I mean, Professor Soman is right that there are very good reasons to think that the presidency is a civil office under the United States, but that reading is quite difficult to square with certain other provisions of the Constitution. Anybody who says that there is a clear or obvious answer to this difficult question is pulling your leg.
Yes, which is why we wanted to have this debate today. Professor Soman, Republicans right now are trying to impeach Joe Biden partly in response to Democrats having impeached Trump twice as a kind of revenge. So what's to stop them from using the 14th Amendment against a future Democratic presidential candidate also as revenge? You acknowledge in your recent piece that using the 14th Amendment against Trump could, quote, likely to lead to dangerous, slippery slope effects. How do you prevent that from happening?
So when I said that, I was summarizing other people's arguments rather than my own views. But I think the obstacle to it happening, as I said before, judicial review. That if this was just up to partisan elected officials or appointed officials for that matter, then there would be a much more serious danger. But we do have judicial review here, and while judges may not be 100% free of political bias, they're not perfect by any means. This provides a significant safeguard.
Last question to you, Professor McConnell. You and I mentioned earlier that we agreed that this will probably end up at the Supreme Court, who will have to decide whether Trump can be disqualified from running under the 14th Amendment, Section 3. Does the Supreme Court want this case? Does Chief Justice Roberts want this? If you were a judge on the Supreme Court, would you be trying to avoid this as much as possible? This is such a major question. And if these justices decide that actually Donald Trump cannot run, it will be probably the most consequential Supreme Court opinion in history, will it not?
That's true. And I think you're right. I think they will be. They're sitting there just hoping that there's going to be some way to get out of it. There may not be. It may be that they really do have to decide the case. But there are a number of procedural complications that could get in the way and keep them from deciding the ultimate question of whether Donald Trump engaged in an insurrection. For example, there are all kinds of timing questions. Is the law? Has anything actually happened? Lawsuits are being filed, but actually, has anything happened yet? Who are the authorities? What there's state law questions about what the reach of state electoral officials is going to be. One very important point, potentially important point, is that Section 3 does not actually keep an insurrectionist from running for office. What it does is it keeps an insurrectionist from holding office. Yes. So arguably, the whole case is not going to be ripe unless and until Donald Trump is actually elected president. And, what a mess that would be. I do think for the good of the country, it would be nice if the Supreme Court, decided this case early on so that everybody knew the rules of the game before we start voting. But I think there's a reasonable shot that they'll say, look, the case isn't before us until someone is trying to hold office in violation.
Ilya Somin, I'll give you the last word.
Yeah, so I think there are going to be procedural difficulties with this. Nonetheless, I think there's a good chance there will be court decisions, possibly all the way up to the Supreme Court within the next few months, well before the November election, because there are different states with different rules as to who's eligible to be on the ballot. And in at least some of them, it may be possible to move quickly. And also there are lawsuits by various people that can be brought, including Trump's competitors, perhaps in a Republican primary or in the general election if he gets that far. So I think there's a good chance this will be resolved before November election. And I do think when it looks like under state laws, in many cases, my understanding is that if you're not eligible to hold the office, you're also not eligible to be on the ballot. And the issue of whether you're eligible to hold it is a federal question that would eventually end up in federal court, even though the initial question of are you eligible to be on the ballot of New Hampshire or Texas or California or whatnot, that would initially be a state law question in the first instance.
We shall see what happens. Professors Michael W. McConnell and Ilya Somin, thank you both for participating in an important and fascinating debate.